Warm good morning to all of you. I hope I'm audible and visible today. There was some technical glitch yesterday. That's why we were unable to conduct the smooth session. And today we are going to discuss MP Civil Judge 2016 question paper, in which we are going to discuss from question number 31 to 60, in which we are going to cover various topics like your Transfer of Property Act and some of the questions from Limitation Act, some of the questions from MP Local Laws, Evidence Act and IPC. So please be in the video till the end. And if you people like our videos, like if you find it informative, don't forget to press the like button and press to subscribe to our channel. And don't forget to check out MP Civil Judge Prelims Crash Course. Link is in the description box. So let's start today's discussion. Good morning, Saksham Sharma. Question number 31. A fresh period of limitation shall be computed from the time when the acknowledgement was. Option 1, signed before expiration of the prescribed period. Option 2, signed after expiration of prescribed period. Option 3, oral agreement before expiration of prescribed period. And option 4, oral agreement after expiration of prescribed period. What should be the correct answer? This particular question is from Section 18 of Limitation Act. So they are stating a fresh period of limitation shall be computed from the time when the acknowledgement was. Option 1, signed before the expiration of prescribed period. Option 2, signed after the expiration of prescribed period. Option 3, oral agreement before expiration of prescribed period. And option 4, oral agreement after expiration of prescribed period. So what should be the correct answer? 31A is the correct answer. If you will read Section 18 of Limitation Act, you will come to know that a particular document acknowledgement signed before the expiration of prescribed period, in that the time period of limitation shall be computed from that time, right? Next question, question number 32. Whether a court can grant extension of period of limitation under Section 5 on the ground of sufficient cause in the cases of, yes, Harshvardhan Gautam, 31 ka A is the correct answer. Sufficient cause in the cases of an application under Order 21 of CPC. Saksham Sharma, yes, 31 ka A is the correct answer. A will be the correct answer, Saksham ji. Now, option 1, no. Option 2, yes. Option 3, with the permission of High Court. Option 4, with the consent of both of the parties. So what should be the correct answer? Question number 32. Whether a court can grant extension of period of limitation under Section 5 of on the ground of sufficient cause in case of an application under Order 21 of CPC. Option 1, no. Option 2, yes. Option 3, with the permission of High Court. And option 4, with the consent of both of the parties. So what should be the correct answer? Now, if you people have read like Section 5 of Limitation Act, it exclusively bars 3 types of cases, right? So it simply states the Order 21 Order 21 of CPC is exclusively barred for granting the time period of limitation. So its correct answer, 32 ka correct answer will be your option A, that is no, right? 32 ka correct answer will be your option A, that is option 1, that is no, right? So an application filed under your Hindu Adoption and Maintenance Act, or any application filed under Order 21 for execution of decrees, all these are barred, right? But the suit or any specific remedy for the suit is also barred. But the time period of limitation can be extended in the case of appeal or application, right? So its correct answer will be your option 1 or option A, right? Next question. 32 Harshvardhan A is the correct answer. Saksham Sharma, 32A is the correct answer. 33. This particular question is from MP Accommodation Control Act, right? I know this particular thing might be boring for all of you, but please be here because you will find lots and lots of questions from this particular chapter in MP Civil Judge exam as well. So if after the tenant has delivered possession on or before the date is specified in the order under clause G or clause H of subsection 1 of section 12 of MP Accommodation Control Act, landlord fails to commence the work of repair or building or rebuilding within dash of specified date on an application made to it, the court may order landlord to place the tenant in the occupation of the accommodation or the part thereof. Option 1, 1 month. Option 2, 3 months. Option 3, 1 month. Option 4, 6 months. So they are stating if the tenant has delivered the possession on or before the date specified in the order under clause G or clause H of subsection 1 of section 12 of MP Accommodation Control Act, landlord fails to commence the work of repair or building or rebuilding within the dash of specified date on an application made to it, the court may order the landlord to place the tenant in the occupation of the accommodation or part thereof. Option 1, 2 month. Option 2, 3 month. Option 3, 1 month. Option 4, 6 month. Vinny ji is saying it's 33 ka 1. 33 ka correct answer is option 3, that is 1 month. 33 ka correct answer is 3, that is 1 month, right? If you will read section 12 of MP Accommodation Control Act, you will find the answer of this question. Next question. Question number 34. Under which section of MP Accommodation Control Act 1961 is provided for fixation of provisional rent? So which provision of MP Accommodation Control Act talks about fixation of provisional rent? Option 1, section 12 subclause 1. Option 2, section 12 subclause 2. Option 3, section 13 subclause 2. And option 4, section 13 subclause 6. So which provision talks about fixation of rent? Which provision talks about fixation of rent? Yes. Provisional rent, right? So which provision of MP Accommodation Control Act talks about fixation of provisional rent? What should be the correct answer? Yes. 33 ka 3 is the correct answer. Yes, Saksham Sharma ji. Now, question number 34. What should be the correct answer? Which section of MP Accommodation Control Act provides for fixation of provisional rent? Yes. Question number 34, 3 is the correct answer. Harshvardhan Gautam ji, you are correct. 34 ka 3 is the correct answer. No, Vinny ji, it will not be 1. It will be option 3. Question number 35. If a landlord receives any rent in excess of standard rent as fixed by the rent controlling authority, he shall be punished with a simple imprisonment for a term which may extend to option 1, 1 month, option 1, 3 months, option 2, 6 months, option 3, 1 year, and option 4, 1 month. Question number 35. If the landlord receives any rent in excess to the standard rent as fixed by the rent controlling authority. Yes, Saksham Sharma ji, 34 ka 3 is the correct answer. If a landlord receives any rent in excess of the standard rent as fixed by the rent controlling authority, he shall be punished with the simple imprisonment for the term which may extend to 3 months, 6 months, 1 year, 1 month. What should be the correct answer? Question number 35. Question number 35. What should be the correct answer? Yes, its correct answer will be your option 1, that is 3 months. Option 1, that is 3 months, right? Now, next question, question number 36. Which one is not correct? Now, which one is not correct? 35 ka 1 is the correct answer. That is the period will be for 3 months, not 6 months. Which one is not correct? The government may, by notification, exempt any accommodation from all or any of the provision of MP Accommodation Control Act. Option 1, which is owned by educational institute. Option 2, which is owned by religious institute. Option 3, which is owned by any charitable institution. And option 4, which is owned by any cultural institution. Question number 36. Which one of the following is not correct? Yahan pe yaad rakhiye, they are asking which one of the following is not correct or incorrect, right? So the government may by notification exempt any accommodation from all or any of the provisions of MP Accommodation Control Act. Option 1, which is owned by any educational institution. Option 2, which is owned by any religious institution. Option 3, which is owned by any charitable institution. And option 4, which is owned by any cultural institution. What should be the correct answer? Question number 36. Its correct answer will be yes. What should be the correct answer? Its correct answer will be your option 4, which is owned by any cultural institution, right? 36 का 4 is the correct answer. याद रखिए, any institution which is managed for educational, religious or charitable purposes, all these may get exemption, right, under MP Accommodation Control Act. So 36 ka 4 is the correct answer. Yes, Harshvardhan ji, 4 is the correct answer. Question number 37. No suit for eviction of tenant shall be maintainable. Yes, Saksham Sharma ji, 36 ka 4 is the correct answer. No suit for the eviction of a tenant shall be maintainable on the ground specified in 12(1)(e) or 12(1)(f) unless a period of dash has elapsed from the date of acquisition. Now, this particular question is a repeated question. If you people have followed a previous question paper, there also we have discussed this question. No suit for the eviction of tenant shall be maintainable on the grounds specified in 12(1)(e) or 12(1)(f) unless a period of dash has elapsed from the date of acquisition. 37. What should be the correct answer? Now, this particular question is taken from section 12, clause 4. It is question number 37. Its correct answer is 1 year, right? Now, clause E and clause F are stating where the landlord claims that he is in bona fide need of the place. He is in bona fide need of the place. Then in that case, if he wants to give that particular property to another person on tenancy, then he has to wait for the period of 1 year, right? 37 ka 1 year is the correct answer. Question number 38. Which revenue officer is competent to take action under section 250 of MP Land Revenue Code? Now, this question is from MP L.R.C, MP Land Revenue Code. Which revenue officer is competent to take action under section 250 of MP L.R.C? Option 1, Tahsildar Revenue. Option 2, Sub-Divisional Officer Revenue. Option 3, Collector. Option 4, Civil Judge Second Class, right? Civil Judge Class 2, which you people are going to become very soon in future, right? So, which revenue officer is competent to take action under section 250 of MP L.R.C? Option 1, Tahsildar Revenue. Option 2, Sub-Divisional Officer Revenue. Option 3, Collector. Option 4, Civil Judge Class 2. What should be the correct answer? Its correct answer is Sub-Divisional Officer Revenue, SDO Revenue, right? So its correct answer is your option 2. 38. Sorry, just a second. 37, 38. No, its correct answer is Tahsildar, not Sub-Divisional Officer of Revenue. My bad. Now, question number 39. 39. Under MP Land Revenue Code, which rights of village entered in Wajib-ul-Arg record? Under MP Land Revenue Code, which rights of village entered in Wajib-ul-Arg record? Option 1, only right to irrigation. Option 2, only right to way. Option 3, only other easement. Option 4, all of these or all of the above. So if you will read section 242 of MP L.R.C, you will come to know that MP Land Revenue, under MP Land Revenue Code, what rights of village entered in Wajib-ul-Arg record? Yes, only right to irrigation, only right to way, only other easement, and for all of these. Yes, Vinny ji, Harshvardhan ji, all of you are correct. Its correct answer. Saksham ji, you are also correct. Its answer is all of these. Next question is question number 40. Under section 113 of MP Land Revenue Code, clerical errors which have been made in record of rights may at any time be corrected by the option 1, Tahsildar. Option 2, Sub-Divisional Officer. Option 3, 3 revenue inspector, and option 4 collector. Under section 113 of MP Land Revenue Code, clerical errors which have been made in the record of the rights may at any time be corrected by the option 1 Tahsildar, option 2 Sub-Divisional Officer, option 3 Revenue Inspector, and option 4 Collector. What should be the correct answer? Question number 40. Its correct answer is yes. Under section 113 of MP Land Revenue Code, clerical errors which have been made in record of right may be corrected by the Sub-Divisional Officer, SDO Revenue. Yes, Harshvardhan Gautam ji. Its correct answer is option 2. Right? Question number 41. According to section 57 of MP Land Revenue Code, where a dispute arises between the state government and any person in respect of any right under subsection 1, such dispute shall be decided by the. Under section 57 of MP Land Revenue Code, where a dispute arises between the state government and any person in respect of, yes, section 40 ka 2 is the correct answer. Now, according to section 57 of MP Land Revenue Code, where a dispute arises between the state government and any person in respect of any right under subsection 1, such dispute shall be decided by the option 1 Sub-Divisional Officer or SDO, option 2 Collector, option 3 Civil Court, and option 4 State Government. Question number 41. Now, where there is a dispute between the state government and any person in respect of any right under subsection 1, such dispute shall be decided by the Sub-Divisional Officer, Collector, Civil Court, and State Government. Yes, Saksham Sharma ji, you are correct. Its correct answer is option 4, that is State Government. Right? So state government is empowered to that. Now, next question, question number 42. According to MP Land Revenue Code, who is not a revenue officer? According to MP Land Revenue Code, who is not a revenue officer? Now, this particular question, question number 42, this particular question is asked numerous of time in MP Civil Judge exam. Option 1, Naib Tahsildar, option 2, Revenue Inspector, option 3, Settlement Officer, and option 4, Assistant Superintendent of Land Record. According to MP Land Revenue Code, who is not a revenue officer? Naib Tahsildar, Revenue Inspector, Settlement Officer, and Assistant Superintendent of Land Record. Yes, Revenue Inspector is the correct answer. Revenue Inspector is not the revenue officer. Yaad rakhiyega, if you will read particularly of section 11 and 12 of MP L.R.C, you will come to know this. Right? So its correct answer is Revenue Inspector. Now, question number 43. First question from Indian Evidence Act. Right? This question is stating, under Indian Evidence Act 1872, which among the following does not come under the category of privileged communication? Under under Indian Evidence Act 1872, which among the following does not come under the category of privileged communication? Option 1, communication made during marriage. Option 2, communication made by a witness who is unable to communicate verbally. Option 3, official communication. Option 4, privileged communication. Yes. Does not come under the category of privileged communication. They are asking does not come under the category of privileged communication. Communication made during marriage, communication made by a witness who is unable to communicate verbally, official communication, and professional communication. What should be the correct answer? Question number 43. Under Indian Evidence Act, which among the following does not come under the category of privileged communication? Communication made during marriage, communication made by a witness who is unable to communicate verbally, official communication, and professional communication. So its correct answer is your option 2, that is communication made by a witness who is unable to communicate verbally. That is not covered under the term which is confined as privileged communication, right? So for question 42, settlement officer was a revenue officer before 2018 amendment. Yes, before 2018 amendment, he was a revenue officer. But like, if you will find this question, you will find this question for now, like after the amendment, right, Harshvardhan? So ideally, its answer, as per my observation, its answer is still for 40 question number. I'm not remembering the exact question number. Its correct answer should be your revenue inspector, because revenue inspector is still exempted, like not exempted. He's not in the category of revenue officer. In which section of Indian Evidence Act the principle of res gestae is enshrined? Question number 44. In which section of Indian Evidence Act the principle of res gestae, that is forming part of the same transaction, is enshrined? Option 1, section 6, option 2, section 7, option 3, section 8, option 4, section 9. What should be the correct answer? In which section of Indian Evidence Act principle of res gestae is enshrined? Section 6, section 7, section 8, section 9. What should be the correct answer? Yes, section 6 is the correct answer. Saksham Sharma, Vinny, both of you are correct. Its correct answer is section 6. Next question. Under Indian Evidence Act 1872, what is not a primary evidence? Yes, Harshvardhan Gautamji, 44 ka 1 is the correct answer. Question number 45. Under Indian Evidence Act, yes, Harpriya Nanda, section 6 is the correct answer. Under Indian Evidence Act 1872, what is not a primary evidence? Option 1, documents made by printing. Option 2, document made by lithography. Option 3, document made by photography. Option 4, document copies of original document. They are asking which of the following is not a primary document or primary evidence. So they are asking which of the following can be considered as secondary evidence, right? Document made by printing, document made by lithography, document made by photography, document copies of the common original. 45. What should be the correct answer? Yes. Question number 45. What should be the correct answer? Its correct answer is your option 4. That is document copies of common original, right? So Harshvardhan, Saksham, Vinny, all of you are correct. Next question. Harpriya, you are also correct. Its correct answer will be option 4. Now, question number 46. That is from Indian Evidence Act. There are two statement givens and we have to find which of the following statement is correct or incorrect. Statement 1 is stating A agrees absolutely in writing to pay B rupees 1000 on 1st March 2010. The fact that at the same time an oral agreement was made that the money should not be paid till 31st of March cannot be proved. Statement 2. A sells B a horse and verbally warrants him sound. A gives B a paper in these words, bought of A horse for rupees 500. B may prove the verbal warranty. Option 1, A is incorrect, B is correct. Option 2, B is incorrect, A is correct. Option 3, both correct. And option 4, both incorrect. Question number 46. There are two statements. First statement is stating that A agrees absolutely in writing to pay B rupees 1000 on 1st March 2010. The fact that at the same time an oral agreement was made that the money should not be paid till 31st March cannot be proved. Option 2, A sells B a horse and verbally warrants him sound. A gives B a paper in these words, bought of A horse of rupees 500. B may prove the verbal warranty. Option 1, A is incorrect, B is correct. Option 2, B is incorrect, A is correct. Option 3, both are correct. And option 4, both incorrect. So its correct answer is option 3. That is the both of the statement are correct, right? Now, let's move further. Question number 47. Under section 45 of Indian Evidence Act, opinion of a witness is Option 1, a conclusive proof. Option 2 is not relevant. Option 3 is not admissible. And option 4 is not a conclusive proof, right? So under section 45 of Indian Evidence Act, opinion of expert witness is option 1, conclusive proof. Option 2 is not relevant. Option 3 is not admissible. Option 4 is not conclusive proof. Yes, what should be the correct answer? Question number 47. Under section 45 of Indian Evidence Act, opinion of the expert witness is a conclusive proof, is not relevant, is not admissible, is not a conclusive proof. So its correct answer is your option 4, that it is not a conclusive proof, right? Question number 48. Presumption as to electronic 47. Yes, Harpriya Nanda, 47 ka 4 is the correct answer. Presumption as to electronic agreements is provided in section dash of Indian Evidence Act. Presumption as to electronic agreements is provided in section dash of Evidence Act. Saksham Sharma, 47. Yes, 4 is the correct answer. Option 1, section 85, option 2, section 85A, option 3, section 85B, option 4, section 85C. Question number 48. Presumption as to electronic agreement is provided in section dash of Evidence Act, 85, 85A, 85B, 85C. What should be the correct answer? If you people have read like section 85, 85A, B and C, you will be having a clear idea that presumption as to electronic agreement is specifically provided. And this question is asked in various judicial exams, right? So its correct answer should be 48 ka 2, that is section 85A. Yes, Saksham, you are correct. Next question. Question number 49. A dying declaration under section 32 of Harpriya Nanda, 45.2 is the correct answer. A dying declaration under section 32 of the Indian Evidence Act is admissible in evidence. Option 1, only when it is reduced in writing. Option 2, even when it is made to a police officer. Option 3, only when it is made to a judicial magistrate. Option 4, only when it is made to an executive magistrate. Now, let me tell you an interesting fact. This particular question, question number 49, I read in hurry, and in the exam of MP Civil Judge 2016, I made it wrong. I made this particular question wrong. So I suggest you people to read this particular question quite carefully before answering. Question number 49. A dying declaration under section 32 of Indian Evidence Act is admissible in evidence. Option 1, only when it is made or reduced in writing. Option 2, even when it is made to a police officer. Option 3, only when it is made to a judicial magistrate. And option 4, only when it is made to an executive magistrate. What should be the correct answer? If you will read this particular question carefully, its answer is quite easy, right? So try to read the question carefully and answer it. Yes, what should be the correct answer? A dying declaration under section 32 of Indian Evidence Act is admissible in evidence only when it is reduced in writing, even when it is made to a police officer, only when it is made to a judicial magistrate, and only when it is made to an executive magistrate. Yes, its correct answer is option 2. Harshvardhan, Saksham, probably you people have applied the same logic which I have applied in MP Civil Judge 2016 exam. Its correct answer is option 2. If you will read option 1, 3 and 4, they are talking only. And you have to remember that when we are talking about a particular thing, that is dying declaration. So in the cases of dying declaration, Harpriya Nanda and Vinny, both of you are correct. Very good, right? So a dying declaration can be made to a police officer as well. But rest of the other options, 1, 3 and 4, they are imposing the only term, right? So its correct answer should be option 2, right? Question number 50. A is charged with traveling on railway without a ticket under Indian Evidence Act, the burden of proving that he had a ticket is on, right? A is charged with the traveling on a railway without a ticket. Under Indian Evidence Act, the burden of proving that he had a ticket is on. Option 1, prosecution. Option 2, accused. Option 3, complainant. And option 4, prosecution witness. Prosecution, accused, complainant, prosecution witness, right? This particular question is like quite direct question. Question number 50. It is from burden of proving a special fact or a special knowledge. So A is charged with traveling on railway without a ticket. Under Indian Evidence Act, the burden of proving that he had a ticket is on prosecution, accused, complaining, prosecution witness. So its correct answer is accused, right? So 52 is the correct answer. Yes, Saksham Sharma, Viniji, you are correct. Harshvardhanji, its correct answer should be 2, not 1, right? Question number 51. Under Indian Evidence Act 1872, the statement of hostile witness is. Under Indian Evidence Act 1872, the statement of a hostile witness is. Option 1 is irrelevant. Option 2 can be acted upon. Option 3 cannot be acted upon. Option 4 has no evidentiary value, right? Now, if you people are aware about Section 154 of Indian Evidence Act, this like when a party may cross-examine his own witness. So that is the situation of hostile witness. In the cases of hostile witness, the statement of a hostile witness is option 1, relevant, option B, irrelevant, sorry, option 2, cannot be acted upon, option 3, can be acted upon, and option 4 has no evidentiary value. So 51, what should be the correct answer? The statement of a hostile witness is irrelevant, can be acted upon, cannot be acted upon, and has no evidentiary value. What should be the correct answer? Question number 51. Yes. Its correct answer is Hanji, can be acted upon, right? So 51 ka 2 is the correct answer. Harpriya, Nanda, Vinny, both of you are correct. Next question. Question number 52. Under Indian Evidence Act, confession of one accused is admissible in evidence against co-accused. Under Indian Evidence Act, the confession of one accused is admissible in evidence against co-accused. So this particular question is from Section 30 of Indian Evidence Act. Option 1, if they are tried jointly for the same offense, right? Yes, Saksham ji, 51 ka 2 is the correct answer. Option 2, when they are tried jointly for different offenses. Option 3, when they are tried for the same offense but not jointly. Option 4, if they are tried for different offense and also not jointly. Under Indian Evidence Act, confession of one accused is admissible in evidence against co-accused if they are tried jointly for the same offense, if they are tried jointly for different offense, if they are tried for the same offense but not jointly, and if they are tried for different offense and also not jointly. Its correct answer is your option 1. So Vinny, Krati, Harshvardhan, Gautam ji, all of you are correct. Harpriyananda, you are also correct. 52 ka 1 is the correct answer. Question number 53. Under Section 230 of Indian Penal Code 1860, which of the following is not or has not been a coin? Rewrite. So, under Section 230 of Indian Penal Code 1860, which of the following is not or has not been a coin? Option 1. Option 1, coin denominated as company's rupee. Option 2, the Farrukhabad Rupee. Option 3, a metal used for the time being as money and stamped and issued by the authority of some state or sovereign power. Option 4, lumps of unstamped metal used as money. So, what should be the correct answer? Question number 53. Which of the following is not coin? Option 1, coin denominated as company's rupees. Option 2, Farrukhabad Rupee. Option 3, a metal used for the time being as money and stamped and issued by the authority of some state or sovereign power. Option 4, lumps of unstamped metal used as money. What should be the correct answer? Question number 53. 53. Yes, Kriti Avasthiji, you are correct. Its correct answer is option 4. That is lumps of unstamped metal used as a money. So fourth is the correct answer, right? Next question. Question number 54. Under Indian Penal Code, which of the following amounts to defamation? Under Indian Penal Code, which of the following amounts to defamation? Now, question number 54. Before you people answer this particular question, read this particular question quite carefully before answering it. Option 1, to convey a caution intended for good of person to whom conveyed or for public good. Option 2, to make an imputation concerning a company or an association or collection of persons as such. Option 3, censure passed in good faith by person having lawful authority over others. Option 4, publication of reports or proceeding of court. Question number 54. Which of the following amounts to defamation? Option 1, convey a caution intended for good of a person to whom conveyed or for public good. Next, to make an imputation concerning a company or an association or collection of persons as such. Option 3, censure passed in good faith by persons having lawful authority over others. And option 4, publication of reports or proceeding of court. So question number 54, 2 is the correct answer. Kriti Avasthiji, Harshvardhan Gautamji, both of you are correct. 54 ka 2 is the correct answer. Question number 55. A, without any excuse. Yes, Saksham Sharmaji, 54, 2 is the correct answer. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Harpriya Nanda, yes, 2 is the correct answer for question number 54. A, without any excuse, fires a loaded cannon. Ankita Gupta, 54 ka 2 is the correct answer. Yes, Ankita ji, 54 ka 2 is the correct answer. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Although he may not have a premeditated design to kill any particular individual, A committed the offense of option 1, section 299 of IPC, option 2, section 300 of IPC, option 3, section 304 of IPC, and option 4, section 304A of IPC. So I'm reading the question again. A, without any excuse, fires a loaded cannon, cannon means a sort of gun, into a crowd of persons and kills one of them, although he may not have any premeditated design to kill any particular individual. A is committing the offense of option 1, section 299 of IPC, option 2, section 300 of IPC, option 3, section 304 of IPC, and option 4, section 304A of IPC. Right? What should be the correct answer? Question number 55. Now, this particular question is directly taken from illustration D of section 300. Right? So, its correct answer should be yes, option 2. I was expecting option 1 from a lot of you. Section 299 is talking about culpable homicide, while section 300 is talking about murder, and where a particular person causes death of another person in such a situation that he has the knowledge that he may cause the death of another person in all the circumstances, right? So in that case, what will happen? It will be considered as murder. So its correct answer should be section 300 That means A should be charged with murder, right? So Kriti Avasthi 55-2 is the correct answer. Harpriya Nanda, sir, please say the correct all reason all along with the correct answer. Okay, so Harpriya Nanda, here I have explained the exact reasoning why its answer should be your section 300, right? I hope it is clear to all of you. Now let's move further. Question number 56. After Criminal Law Amendment Act 2013 to the Indian Penal Code, the offense of gang rape is punishable under section 376(2)(g), section 376(b), section 376(c), option 4, section 376(d). Yes, obviously he had the knowledge here, like by the circumstances, Harpriya Nanda, in the previous question we can derive the conclusion that the person had the knowledge. When you are firing like in front of thousands of people standing over there, in all probabilities it will cause death of a person, so it is quite obvious, right? So then in that case we may draw the conclusion that he had the knowledge, right? So after Criminal Law Amendment Act 2013 to the Indian Penal Code, the offense of gang rape is punishable under which section? Its correct answer is option 4, that is section 376(d). Yes, Kriti Avasthi ji, Saksham Sharma ji, Ankita Sharma ji, Ankita Gupta ji, Harshvardhan Gautam ji, Harpriya Nanda ji, all of you are correct. Question number 57. Removal of ornaments dishonestly from the body of deceased person. Here there is no gap, so this is like typing error. Person is option 1, robbery under section 392 of IPC. Option 2, theft under section 378 of IPC. Option 3, an offense under section 404 of IPC. Option 4, an offense under section 416 of IPC, right? So removal of ornaments dishonestly from the body of a deceased person is robbery under section 392 of IPC, theft under section 378 of IPC, an offense under section 404 of IPC, and the last option, an offense under section 416 of IPC. What should be the correct answer? Yes, removal of ornaments dishonestly from the body of deceased person is robbery, theft, dishonest misappropriation of the property under section 404 and 416. Yes, Harpriya Nanda, Kriti Avasthi, all of you are correct. Its correct answer is option 3, that is an offense under section 404 of IPC. Now this is a specific provision. Yes, Saksham Sharma, you are also correct. This is a specific provision provided under 404 of IPC. That is, if a person dishonestly takes any ornaments or any valuable property from a dead body, that will be considered as dishonest misappropriation of property taken from a dead body, right? So 404 is the correct answer. Next question, question number 58. Under section 511 of Indian Penal Code will apply to. Section 511 will apply to. Yes, Ankita Gupta ji, 57 ka 3 is the correct answer. Section 511 of Indian Penal Code apply to option 1, attempt to commit murder. Option 2, attempt to commit suicide. Option 3, attempt to commit theft. And option 4, attempt to commit robbery. Attempt to commit murder, attempt to commit suicide, attempt to commit theft, and attempt to commit robbery. Question number 58. What should be the correct answer? Yes. Section 511, which is talking about attempt. Okay, half of the punishment should be given for the attempt of a particular offense. This particular provision is section 511 of IPC will be applicable on attempt to commit murder, attempt to commit suicide, attempt to commit theft, attempt to commit robbery. Yes, its correct answer is option 3, that is attempt to commit theft. Now, attempt to commit murder is already defined under your section 307. Attempt to commit a suicide is already defined under 309. Yes, and attempt to commit robbery is also defined under section 396, right? So all these attempts are separately defined. So its correct answer should be option 3. Yes, Harpriya Nanda, Ankita Gupta ji, you are also correct. Next question, question number 59. Under Indian Penal Code, which of the statement represents the correct position of law to constitute abatement it is? Under Indian Penal Code, which of the following statement represents the correct position of law? To constitute abatement it is option 1, necessary that the act abated must be committed. Option 2, not necessary that the act abated must be committed. Option 3, necessary that the person abated must have the same intention or knowledge as that of the abater. And option 4, none of the above. None of the above or none of these, right? Under Indian Penal Code, which of the statement represents the correct position of law? To constitute abatement, it is option 1, necessary that the act abated must be committed. Option 2, not necessary that the act abated must be committed. Option 3, necessary that the person abated must have the same intention or knowledge as that of abater. And option 4, none of these or none of the above. What should be the correct answer? 59. Yes, Harpriya Nanda, Harshvardhan Gautam, all of you are correct. 59 ka 2 is the correct answer. That is, it is not necessary. Saksham Sharma, you are also correct. Kriti Avasthi, 1 will not be the correct answer, because if you will read your section 107, you will simply find that it is not necessary that the act abated should be committed to constitute the offense of abatement, right? So 59 ka 2 is the correct answer. Now, next question, question number 60. A cuts down a tree on B's land with the intention of dishonestly taking the tree out of B's possession without B's consent. Which offense is committed by A, right? 59, Ankita ji, 3 will not be the correct answer. Its correct answer will be option 2. Right, this is given under section 108 explanation 2, right? Question number 60. A cuts down a tree on B's land with the intention of dishonestly taking the tree out of B's possession without B's consent. Which offense is committed by A? Option 1, robbery. Option 2, criminal breach of trust. Option 3, extortion. And option 4, theft, right? So question number 60, what should be the correct answer? A cuts down a tree on B's land with the intention of dishonestly taking the tree out of B's possession without B's consent. Which offense is committed by A? Option 1, robbery. Option 2, criminal breach of trust. Option 3, extortion. And option 4, theft. Yes. Question number 60, its correct answer is option 4, that is theft. This is like the particular illustration taken from section 378 of Indian Penal Code, right, which is defining theft. तो वहां से सीधा illustration उठा के paste किया हुआ है. And MP do this thing, like MP in MP civil judge exam, you will always find illustration directly from the bare acts. So the correct answer is given by Kriti Avasthi, then Harshvardhan Gautam, and then Ankita Gupta. Harpriya Nanda, it is not robbery, right? So, and Saksham Sharma, yes, 60 ka 4. It will not be robbery because to constitute the offense of robbery, we require some sort of like use of physical force, okay, or some instant threat or fear of death or injury. But that was absent in this case. So question number 60, that's why its correct answer should be theft. And this is the direct question from the illustration of section 378, right? So if you people enjoyed the session till now, don't forget to like the video and to subscribe to our channel. Usually, like regularly, I come up Monday to Saturday, 9 a.m. to 10 a.m. in the morning. If you people haven't followed up till now previous year question papers, okay, sir, by mistake, I have chosen option 1. It's correct. It's completely okay. Harpriya Nanda. Okay. So what I was stating, you people, yes. So I hope all of you are quite clear with it. Now, if you people haven't followed up the previous videos, like we have already discussed MP Civil Judge 2019, 2018, 2017 question paper of all the shifts. We have also prepared the videos of MP specific GK, like which was something which the students were lacking. Thank you, Harshvardhan. Thank you, Saksham. So which the students were lacking, like MP mines, MP tourism, MP history, MP rivers, MP wildlife, national parks. So do follow up those videos as well. That can help you a lot for your MP preparation. And we have also started MP Civil Judge Prelims Crash Course. Link is in the description box. Do check it out, in which you will find 10+ mocks, one-on-one mentoring and doubt clearing session, recorded video lectures of all the subjects. So that may help you. Thank you, Saksham. Thank you, Kriti. See you all in the next class, like tomorrow at 9. Meanwhile, take care. Bye-bye. Stay healthy, all of you.